oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2014 AMC Entertainment Holdings against iPic-Gold Class Entmt from Harris County and the First Court of Appeals District. Then 2396 Signature Industrial Services against International Paper from Jefferson County and the 13th Court of Appeals District. Justice Huddle is not participating in the decision of that case. And then 2451 Energen Resources against Wallace from Reeves County and the 8th Court of Appeals District. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess between the cases. The arguments are being webcast live this morning and will be available in the archives later today. We're ready for argument in 2014.
May it please the court, Mr. Schwartzendruber will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you. May it please the court. As the court knows, the trial court below granted traditional and no evidence summary judgments in favor of AMC on two distinct issues. That AMC established by uncontroverted evidence that there was no horizontal conspiracy between AMC and Regal to coordinate their respective clearance requests related to iPic theaters in two distinct markets hundreds of miles apart. And secondly, that the horizontal conspiracy claimed by iPic did not cause injury to iPic, thus defeating the Texas Antitrust Act claim. This court now examines whether the First Court of Appeals erred in reversing those summary judgments. Respectfully, it did on both fronts. In beginning, I want to note that this case has far-reaching implications for the antitrust law of the state of Texas and for businesses seeking to engage in healthy, vigorous competition here. Upholding the standards set by the First Court of Appeals for summary judgments in Texas antitrust cases would have at least two broadly negative effects. First, it would directly contravene the Texas Antitrust Act, the purpose and construction of which are codified at section 15.04 of the Business and Commerce Code, which expressly provides that the statute, and I quote, shall be construed in harmony with federal judicial interpretations of comparable federal antitrust statutes. Yet upholding the Court of Appeals decision would divorce Texas antitrust conspiracy standards from the mainstream of federal antitrust conspiracy law by dramatically liberalizing the types of evidence that will and will not suffice to create a fact issue on antitrust conspiracy. And that can only have the effect of inviting speculative lawsuits against businesses doing business in Texas. Secondly, invoking a serious concern that has been written on by numerous federal courts, upholding the Court of Appeals decision would have a potentially dramatic chilling effect on perfectly legitimate competition in Texas, which is the exact antithesis of the purpose of our antitrust laws. Respectfully, that's not the law in Texas, and it would be horrific policy for Texas and for those seeking to do business here. In the limited time I have, I want to discuss two specific points where the Court of Appeals erred. Those are, first, the fact that the Court of Appeals disregarded significant and fundamental limits that substantive antitrust law places on inferences that are permitted to be painted from circumstantial evidence in order to support a claim of antitrust conspiracy. The second is whether AMC established by competent, uncontroverted, direct evidence the absence of a fact issue as to a conspiracy with Regal. In the interest of time, with respect to the summary judgment granted in favor of AMC on the issue of lack of causation, We will simply stand on our briefs, absent, of course, questions from the court regarding the causation arguments or any points raised by opposing counsel that I feel need to be addressed in rebuttal. To begin, per the United States Supreme Court holdings in Matsushita and Twombly, substantive antitrust law of conspiracy severely limits the range of inferences that are permissible from circumstantial evidence in order for such evidence to be competent to even raise a fact issue for the purpose of summary judgment. Stated in terms of Texas summary judgment parlance, substantive antitrust law limits what circumstantial evidence can serve as even a scintilla of evidence in order to create a fact issue under Texas summary judgment practice. That limitation is specific and it's clear. In order to be competent evidence of an antitrust conspiracy, circumstantial evidence must tend to exclude the possibility that the conduct was the product of independent action or independent business judgment of the actors. If the
Schwarzenegger, that's the federal standard, but under Texas summary judgment practice, you have to show conclusively, if you're the moving party, that there's no conspiracy. And so I took your brief to say, I understand that the federal summary judgment standard is different, but I took your brief to say that you had showed conclusively that there was no conspiracy, and then that they had not raised a fact issue. Isn't that the way we have to analyze it, at least on the traditional summary judgment motion?
With respect to the traditional summary judgment motion, I believe that is exactly correct. And I will also touch upon the evidence that did in fact conclusively establish the traditional motion. But with respect to both grounds, ultimately the claim of iPic here is that they raised, by purely circumstantial evidence, everyone agrees this is nothing but a circumstantial evidence case. And we're not claiming that they have to raise fact issues by direct evidence. Let's be clear. iPic says that, and that is not our position. Our position, however, is that pursuant to the Texas Antitrust Act and its mandate that federal standards be followed, what can constitute competent evidence of a conspiracy, what circumstantial evidence can constitute competent evidence of a conspiracy in the antitrust context must be evaluated under federal law to determine whether it is adequate to raise even a scintilla of evidence that could support a fact issue either in the context of a traditional summary judgment motion or a no evidence summary judgment motion.
What evidence is iPic relying on that AMC says the court should not rely on?
Well, I think we should begin by virtue of the 6 purported plus factors that the First Court of Appeals identified. And if you go through their opinion, first of all, I should say that plus factors as a label don't magically confer special powers upon circumstantial evidence. Whether something is labeled as a plus factor or not, it still must tend to exclude the possibility of unilateral conduct in order to create a fact issue at all. But with respect to the 6 plus factors that were identified by the First Court of Appeals, those included motive, they included opportunity, and they included against interest behavior, among others. And in each instance, if you look at those and break them down in terms of the federal antitrust standards, the courts uniformly hold that evidence of the type that they have relied upon, both iPic and the Court of Appeals, simply does not tend to exclude the possibility of independent conduct. And I can give the court some examples.
What's your best case on the one about the opportunity to conspire and sharing of information that you would say, the federal case that you would say says that what they've produced is not sufficient to show a plus factor on that one?
Probably Texaco versus Dagger. And if you're talking, when you say the opportunity to conspire, if we're talking about by virtue of meetings, joint venture meetings, because the courts have uniformly held, that's opportunity evidence, of course, and the courts have uniformly held that with respect to meetings that have an otherwise legitimate purpose, in this case, the business of a legitimate joint venture between AMC and Regal, the open road distributor, that if those meetings have that ostensible purpose and there's no evidence that other things were discussed, improper things, then that does not tend to exclude the possibility that those meetings were for exactly the purpose that they were intended. It's no evidence of conspiracy whatsoever, and that's true under the case law, even if it is followed subsequently by parallel conduct by the purported conspirators. That's the Valspar case.
What about the evidence that AMC asked Open Road to find out Regal's clearance strategy, which I take there's at least some evidence that that was inconsistent with Open Road's information sharing guidelines, and then also that AMC noted further conversation was needed with Regal regarding clearance swapping?
So, a couple of things in that regard. With respect to the first issue, the policy that you're talking about, the Open Road policy, prohibited the parties from obtaining confidential and proprietary business information from Open Road or exchanging it through Open Road. There is nothing confidential and proprietary about clearance requests whatsoever. They are made uniformly to all distributors. They are out there in public. It's in the record that there's a service called Rent Track that tracks every single day at every single theater in the United States exactly what movies that theater is playing and whether or not the theater down the street is also playing the same film. This is absolutely public information, and there's absolutely nothing confidential about it. So there was no violation of Open Road's policy. That's first. Second, the cases say that it is completely normal, natural, and expected for competitors to utilize any means possible, that's not illegal, of course, but to learn information about what its competitors' strategies are, because you may want to follow them. You may want to try to refute them, and that's legitimate competition that we don't want to thwart. The whole idea behind all of these cases is that if we simply allow evidence of opportunity or supposed motive, which Twombly tells us if the motive is to dissuade competition, that's a universal motive. That's like trying to make money, and you can infer nothing from that. That's black letter law from Twombly. But the bottom line is we don't want to have a chilling effect and allow people who, for example, communicate with competitors for completely legitimate purposes, joint ventures, trade associations, those sorts of things. We don't want them having to be concerned that if you go to a trade conference and speak about legitimate advancement of whatever business you're in with a competitor at that trade conference, we don't want you to have to be worried that you're going to have to either possibly face wearing an orange suit or that you're going to ultimately have to face a jury because someone pleads that you may have talked about prices at that meeting, or you may have talked about clearances at that meeting. And therefore, the standard is that if the circumstantial evidence presented does not tend to exclude the possibility that you communicated for the exact reasons you were supposed to be communicating, then it is no evidence of conspiracy at all.
What would be evidence of conspiracy?
Obviously, if there was something to suggest, for example, that there were in fact conversations about a different subject at that meeting, that would in fact take us outside the context.
For example?
For example, if a meeting was about Open Road business, for example, and there were evidence via email, via testimony, via anything to controvert that suggested that in fact a broader array of subjects was discussed, such as clearances in these two disparate markets, then that would suffice.
Does the note that further conversations are needed regarding clearance swapping suggest that there were already some conversations about clearance swapping?
Well, let's be very clear. The conspiracy here is supposed to be about clearances against iPic-Houston and iPic-Frisco. And of course, iPic-Frisco didn't even exist, and no clearances were ever granted, and that claim has been dropped. Those discussions, even taken in their best light, the way iPic claims they happened. First of all, there's no evidence that any discussions ever did happen. There's only evidence that discussions were contemplated.
But why is further conversation not evidence of a prior conversation?
Well, I think that's reading things pretty strictly, but let's assume that it is. In every single instance, those situations related not to anything having to do with new clearances with respect to iPic or dine-in theaters or clearance policies or anything else. They purportedly had to do with eliminating clearances that already existed in places thousands of miles away. Shirlington, Virginia, Atlanta. I believe there are 3 instances where they talk about, they were talking about going light on one another. Well, if one assumes for a second, and you'd have to make a ton of assumptions here, that AMC and Regal should not be talking about eliminating clearances as between themselves, then that's another claim for another day for some other party. That has nothing to do with iPic, and I would refer the court, pardon me for a moment, to the In Re Elevator antitrust litigation case out of the Second Circuit, 502 F3rd 47, which specifically holds that evidence of purported communications or even conspiracy elsewhere on related but not the same topics is no evidence that tends to exclude the possibility of independent conduct with respect to iPic theaters.
In your last few seconds, just anticipating your opposing counsel's arguments, help us understand, when does a legitimate joint venture between 2 competitors or discussions among them about starting a joint venture cross the line to become conspiracy to commit antitrust violations?
Well,
What's the standard there that we should be measuring? Whatever, I understand there are arguments about whether the evidence is enough to meet the standard, but what is the standard? When does joint venture, which is legit, become illegal antitrust activity?
Well, it would obviously depend on what form of illegal antitrust activity was at issue, but joint ventures, there are standards that have been well addressed by the federal courts in terms of that joint ventures, in order to be valid, have to be for pro-competitive business purposes and as a general proposition, because this is a very broad and involved area of the law, that they need to promote some pro-competitive purpose. There's been no challenge in this case to the fact that Open Road is a limited distributor that was jointly owned by these two companies in order to distribute certain types of novel films. There's been no challenge whatsoever to Open Road as a legitimate joint venture. To your first question about when would it cross the line, if someone was proposing, let's have a joint venture to create a distributor, but our real purpose here is to figure out if we can coordinate clearance strategies against dine-in theaters in order to try to maximize their impact, et cetera. It's very hard for me to answer that question because one must realize that from our perspective, this conspiracy makes no sense in the first place, because the undisputed evidence is that Regal had been granted clearances for years unilaterally. The testimony is that as far back as, the evidence is, as far back as 2010, and I think I saw this in some of the materials that were submitted by counsel, AMC had unilaterally requested clearances with respect to a dine-in theater and successfully gotten them. There's nothing to explain what would motivate either creating a joint venture or any other reason for these 2 theater companies to need to conspire with one another to request clearances when they already knew they could get clearances unilaterally because they had done it in the past. And the law teaches us that conspiracies have to make sense. That's an overriding factor before you ever get to the issue of whether the circumstantial evidence at issue tends to exclude the possibility of unilateral conduct. And this conspiracy, frankly, makes no sense.
Any other questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Ms. Pfeiffer will present argument for the respondents.
May it please the court. What is so extraordinary about this case is that we have all the most critical facts in writing. We have documents that show the plan, that show the execution, that show the follow-up.
Could you answer the question that Justice Boyd presented, which is, where's the line between improper antitrust activity and just regular joint enterprise?
Right, and I'll make it specific even to his question about joint ventures. Business rivals can form joint ventures, but they have to be very careful about how they communicate when they do that. And so Open Road had information sharing guidelines, and I would encourage the court to read that cover to cover. It's a very specific contract that spells out exactly what they cannot do. They cannot share competitively sensitive information, and the reason is because that would be an antitrust violation to do that. And it spells out in no uncertain terms that it could be construed as evidence of an antitrust violation if they present to each other anything that's competitively sensitive. Now, they stood here and said there was nothing confidential about sharing their clearance strategy, and we have included the presentation in the bench exhibits where it's marked confidential. What AMC presented to the Regal executives was their national strategy going forward about how they had determined, after much analysis, to deal with these startup competitors. And they created a national strategy, presented it to the Regal executives, marked it confidential, and they have fought hard over our objection to keep this under seal. It is not accurate to say that this is publicly available information, and these clearance strategies are not something that competitors can go figure out by looking at schedules or publicly available information. What they were doing in this case was sharing future plans years out before theaters ever opened about how they were going to communicate to the theaters and to the distributors about the kinds of clearances that they were going to request to deter these theaters from ever entering the market.
I understand the Regal distributor conspiracy. I mean, I can see why you would get together with a supplier and try to edge out a competitor. It's harder to understand why two exhibitors on the same level would conspire. What did AMC or Regal have to get out of that?
Look at the map that we've included at tab I of the bench exhibits, and you can see just in Houston, the AMC locations and the Regal locations. AMC could not block all the 3-mile radiuses on its own, but if it got Regal to join its plan, they could collectively block out all the areas where these premium dine-in theaters would want to place a theater. I mean, think about it. A premium dine-in theater can't just go on any street corner. In Houston, it wanted to be in River Oaks. And if Regal did this 3-mile clearance strategy, they could block out Memorial, River Oaks, Westview, any place that you'd want to launch a premium dine-in theater. And so AMC had incentive to get Regal on board so that they could collectively, at least in Texas, they blocked it from Houston and Dallas.
Had Regal already requested and been granted a clearance for the Landmark Theater near its Greenway Theater long before any of this evidence came to be?
There is evidence that they had an art clearance, which is a totally different type of clearance. As you know, Landmark was a small art house theater. So they had a totally different type of clearance.
But does that demonstrate that Regal could unilaterally request and obtain a clearance without any horizontal conspiracy?
Yes, every theater, and they're supposed to unilaterally do this independently, but theaters can ask for clearances. They have to be reasonable. The Paramount Pictures case from the United States Supreme Court puts limits on the type of clearances that are permissible, that aren't illegal restraints of trade. And Regal's testimony is that they had been doing some clearances, but they were mutual clearances. They're probably better called allocating, where they take turns with other theaters. But let me go to the point of what Regal's prior practices had been, because it's a cornerstone of their argument that Regal had been doing these clearances already, so it didn't change its policy. That is not true. And look at what they're citing for that. They're citing to Amy Miles, Regal's CEO, her testimony early in this case at the temporary injunction hearing, where she said, oh, we've had this longstanding 3-mile clearance policy. We didn't have the documents at the time or the rest of the depositions, but we later got the documents to show they had not been clearing premium dine-in theaters. Ted Cooper, the head of film for Regal, testified this was a change in policy that happened in January 2013, right after AMC had presented its national strategy to Regal in December of 2012. So AMC shares its strategy in violation of the information sharing guidelines in December 2012. Regal in January 2013 has a new policy. And Ted Cooper says this policy came to him as a top-down directive from the COO who had been on Open Roads board. The decision was made by Regal's CEO, who'd been on Open Roads board, and they did this without any analysis. You don't do clearance strategies without analyzing whether the two theaters are in substantial competition. That's the test under Paramount Pictures to make sure that these are reasonable and legitimate restraints of trade. They didn't do any analysis. They had a top-down directive right after AMC's presentation. We have information showing that when Regal had tested the iPic clearances on its own, it tested it here in Austin, and determined it didn't make sense to clear iPics. They don't present enough of a competitive threat to warrant doing clearances. They didn't clear Studio Movie Grill in 2012, so it had not been part of Regal's business strategy to clear these premium dine-in theaters. But they changed that strategy after hearing AMC's presentation. And then look at the execution.
But if it didn't make sense, that's what's hard for me to understand. Why? I understand why Regal might decide to do it on its own. I don't understand why Regal would care whether AMC did it or not, or vice versa.
Well, partly because they're much more effective if they do this jointly. Partly because if they make a joint statement, both to the iPics of the world and to the distributors, they're far more likely. I mean, think about this for just a minute. Regal and AMC are Coke and Pepsi of movie theaters. They are number one and number two. They are the industry behemoths. And if they're collectively telling iPic, we will clear you if you build a theater in our territory, the iPic's going to have to go reimagine its business strategy. The distributors are more likely to agree to this.
That seemed like competition.
It's not competition to drive an upstart out of business. This is, think about this. Collusion is not a business strategy. And it's anti-competitive to try to drive out new businesses from the marketplace.
Well, only if there's two other competitors conspiring to do it. I mean, is it illegally anti-competitive for AMC to drive iPic out of business?
Yes.
You can't. A competitor's not allowed to drive their competitor out of business. Let
me be clear. Forget the horizontal conspiracy for just a minute. Could AMC or Regal do this type of clearance on its own? The answer is no. That's what the first court already upheld in the temporary injunction. That's the vertical conspiracy with the distributors. And the reason the answer is no is because this is an unreasonable clearance. This is not your typical historical clearance that's targeting an existing theater and making some kind of reasonable clearance request. These clearances on the vertical level violate Section 1 because they are not against a theater that's in substantial competition.
What I thought the allegation with the Regal and the distributors was that they conspired together. It might not have been in either Regal's or the distributors' best interest, but they got together because they wanted to drive iPic out of business. And I can see that's illegal. But if Regal says, we just don't like dine-in theaters, and our competitive strategy is to drive them out of business, and the distributor, you, Mr. Distributor, you should act in your best interest, but we want all these clearances, and this is what we're going to do with them.
But that is the Paramount Pictures case. You cannot ask for clearances against theaters that are not in substantial competition. That is an antitrust violation. So remember, I mean,
So do you take the position that you're not in substantial competition because you offer, your offerings are more upscale and they're small, and the theater's smaller, but isn't the product the same in that both theaters are showing a movie, albeit in a different setting, at a different price, but aren't they really competitors?
not in the sense of whether they're in substantial competition under the Supreme Court's test.
Even if you limited the marketplace to the Houston area or the Greenway, River Oaks area, as opposed to the nationwide, what is the relevant market here? Is it the whole country, or is it just this region of Houston?
Well, and to be clear, in a horizontal conspiracy, you're not looking at relevant market. So this is a per se violation where you don't have to do a rule of reason analysis. But the conspiracy was a national conspiracy.
Okay.
We have sued under the TFEAA just for Texas conduct, but they were doing this elsewhere. I mean, AMC's been sued in Georgia. They've been sued in federal court in Houston. They've done this to other types of theaters. They've done it to Viva and to different kinds of premium dine-in theaters. We're just representing iPic in Texas. But
So what's the Texas conduct then?
in what respect?
To prove the horizontal conspiracy?
Well, so after AMC presented its strategy, we know that Regal adopted it by changing its strategy with respect to these premium dine-in theaters. So we can see by conduct that Regal is doing exactly what AMC said was its national strategy. And then look at the execution. Look in 2014 at what they do. They've already told the iPics that, by the way, we're going to clear you. If you plant your theater here, we will clear you. Then they start executing it with respect to the distributors. And you can see in May of 2014, as soon as AMC learns about an iPic Frisco being planned, it drafts up its email to the distributors, and then it sits on it, and it doesn't send it right away. So in June of 2014, it says, this is ready to send. It sits on it, and it doesn't send it right away. Then they have an email saying, this is ready to go on July 1st, but they don't send it. And on July 2nd, AMC's Elizabeth Frank, who was the mastermind of the strategy, and she sits on the Open Road Board, talks with Regal's general counsel, Peter Brandow, and then right afterwards, on July 8th, 2014, simultaneously, on the same day, they contact all 6 studios and say, we're asking for clearances for these 2 different iPics that are not even opened. They are not even competing, but they're saying, years out, we want clearances against these iPics. And all of this gets back to iPic. The distributors contact iPic and said, we're getting all these calls, what's going on? It was a surprise to the distributors to find out that iPic Frisco wasn't even under contract yet. This is a concept. It's not substantial competition.
To be clear, what you're saying, though, is that it would have been illegal under the Antitrust Act for Regal to do these things even if they'd never had any communication with AMC.
Yes.
AMC never shared its plan or no communication. There would have been a different case than the one you've brought here, but it would nevertheless have been illegal conduct?
Yes. Okay. So that the TI that's already been upheld in this case was the vertical conspiracy.
And then you get AMC on the hook for having conspired with Regal to commit that conduct as your case.
Precisely.
Yeah.
And, AMC has been sued in federal court in Houston for its vertical conspiracy for driving out Viva. It's a Spanish language premium dine-in theater that was launched in Houston in 2013. AMC did this strategy against Viva, and in 6 months, Viva's out of business. So they've been sued there, and summary judgment was denied in that case.
Debra, could you help me with this concept of kind of overarching plausibility? And I'm thinking in particular about evidence in the record that suggested that the presence of an iPic nearby actually grows the market and helps the megaplexes. So why then would the megaplexes be motivated to get rid of the iPic?
That's a great question. It grows the market in the sense that more people go to the movie theaters if you have these premium dine-in theaters as a choice for customers. But it does have some slight negative impact to the operating revenue or cash flow. And so AMC did this very detailed analysis that's in the record where they showed that if they're competing alongside an iPic, it has about a 2.5% negative impact on their operating cash flow. But if they do clearances, it hurts them to 25%. Clearances are far worse for them. And the email says, you can see in the spreadsheet at the iPic tab why Regal chose not to clear iPic. That was AMC's internal analysis determining that it doesn't make sense to do clearances against these. So that's why these are not traditional clearances. This is a strategy of boycotting the distributors in order to get the distributors to not license to these theaters, to use their market power to prevent the premium dine-in theaters even from opening. They're trying to deter the theaters even from coming within their range. And Chief Justice Hecht, to further answer your question about just motive and why do they want to do this, they want to do dine-in theaters themselves. AMC and Regal had been in the business of megaplexes. The market was saturated with megaplexes, and they see these dine-in theaters, the Studio Movie Grills, Alamo Drafthouse, iPics, really becoming a popular option. There is a market for that. And they wanted their own premium dining concept. And so you'll see early in our timeline, for years, they were looking at this, and there's internal emails saying, we wish we had this concept. AMC created its own dine-in theater concept in 2008, and now it has 50 of them. But they're second to market if they don't use sharp elbows, and they used sharp elbows that were antitrust violations. They wanted to get out ahead.
It's your position that there are a number of pieces of evidence in the record that go beyond mere speculation and inference upon inference that actually do create the fact issue, the plus factors and so on. What's your best piece of evidence?
Well,
what do you need to look to find some mere scintilla of evidence that prevents summary judgment?
I like my evidence as a whole, but if I had to convince you, if you weren't convinced yet, and I said, let me just show you this email. It's the email in November of 2015 that's after iPic Houston has opened, right after that opening weekend, Regal starts assessing the damage from its boycott strategy. So Regal Greenway decides not to play the Peanuts movie, and iPic plays it, Regal Marquee out on I-10 plays it, AMC plays it, and Regal can look and see how did this play with all these other theaters if we sit on the sidelines, Greenway. And it notices iPic tanked on Peanuts. They didn't do very well at all, but the customers all went out to Regal Marquee. So Regal Marquee overperforms if Greenway sits on the sidelines. But then in this email, Regal says, but the problem is AMC didn't get the benefit. Now, why does Regal care that AMC didn't get the benefit? It should be happy that Marquee overperformed, but there's no good explanation for why it matters one bit to Regal that AMC is not benefiting from its own self-inflicted body blow of not showing a major first-run film.
Was that an email of disappointment or an email of encouragement in that our theater that is also near iPic got the benefit, not another competitor's theater?
Well, I think that's going to be for the jury to sort of interpret and listen to the witnesses explain this, but it doesn't make any sense at all for it to be a problem to Regal, from their perspective, that AMC is not performing well if Greenway's sitting on the sidelines.
No, it would be helpful, right? So if Regal has two theaters and it clears one and not the other, but the customers go to the other and don't go to its competitor, why is that evidence of a conspiracy?
The evidence is that Regal thinks it's a problem that AMC's not benefiting. So if Regal thinks it's a problem that its competitor doesn't get the benefit of it, they may be concerned.
So that's what the email says. It says that there's a problem because
Yes.
Okay.
Yes. So
that might show that they're friendlier than they ought to be, but what does that have to do with iPic and this particular conspiracy?
well, it shows that Regal cares about AMC benefiting from Regal's boycott. So they care about being in this together. Now, this isn't a direct confession, But you don't need direct confessions in antitrust cases. I mean, I think their position is tantamount to saying that unless the defense witnesses take the stand and admit to everything, we can't let the jury make reasonable inferences. All the Matsushita standard says is that the inferences need to be reasonable. You need to have something more than just suspicion. And in this record, if you go just document by document, go through the PowerPoint, go through the emails, go through the evidence that they've actually shared clearance strategy about a studio movie grill, that they are actually talking to each other about things they should not be communicating about. And then they've got this coordinated, simultaneous conduct, and then they care that one of them's not benefiting from a boycott. Theaters don't refuse to show Star Wars or Hunger Games or the latest James Bond movie without them doing something improper. It shows that this was something that they should not have been doing and that they're jointly doing it.
Any other questions? Thank you, counsel. Mr. Schwarzenegger, I think you've got 5 minutes.
Thank you, Justice Hecht. I'm going to move around a little bit here because there was a lot there. First, I want to begin with an observation you made, Justice Hecht, that is absolutely and exactly correct, which is that Regal, on its own, can aggressively seek to thwart new competition in the form of iPic theaters. That is the Twombly case. Twombly says that is absolutely a natural means of competition and is no evidence of conspiracy whatsoever. That was exactly the facts in Twombly. The claim was that in various markets, the Baby Bells were acting exactly the same way to try to drive out new local phone competition, and Twombly said, that's no evidence of conspiracy at all.
But they can't do it in a way that violates Paramount vertically.
Well, and that is, you've hit upon the next thing. Justice Boyd, you asked about this as well. I've heard a complete spin here in this argument, which is, well, this conduct was illegal anyway. This conduct violated Paramount. This conduct was over illegal clearances. And someone asked, would that, I think it was you, Justice Boyd, wouldn't that be a different lawsuit? The answer is no. That's this lawsuit before. That's the lawsuit that they settled with Regal. They claimed that Regal acted illegally in violation of Paramount because it wasn't in substantial competition, and they settled that lawsuit. That lawsuit is gone. That claim is gone. And let's be more clear. They sued AMC for that same conduct as well with respect to Frisco. They said the request for clearances in Frisco was illegal for all of the reasons that counsel just said, and we got summary judgment on that. In all respects, that claim was dismissed with prejudice on summary judgment, and they did not appeal. There is no vertical conspiracy claim in this case. Let's be clear.
So although Regal settled, it'd be your position that Regal should have gotten summary judgment on the claims against Regal?
They absolutely should have, because we did. We pursued it, and it was determined that it was conclusively established that there was no violation with respect to the vertical request for clearances in Frisco. The next thing I want to address, I heard no less than, I believe, 4 times, AMC presented its clearance strategy to Regal. That is, with all due respect, a blatant misrepresentation of the record. The evidence is that AMC's clearance strategy in December of 2012 was presented to the management of Open Road. None of the board members of Open Road who sit at Regal are on the management team. And there's no evidence that any of them ever saw that presentation at all, not a shred of it. The statement that AMC presented something to Regal is simply false.
But why do they have to be on the management team? What case says that?
It doesn't. It says, first of all, the cases say that communications through intermediaries don't make sense because if you were colluding, you could do it directly. But my point is, she kept saying they produced this information to Regal, and they didn't.
So there was nobody from Regal in the room?
No, there was Open Road people there, not the Regal board members.
I didn't ask about board members. Was anybody employed by Regal in that meeting?
I don't believe there's any evidence to that effect, and I don't believe that is true. But let's also be clear about one other thing. This is also in the record. That presentation had nothing uniquely to do with Open Road. That presentation was published in individual presentations just like the one to Open Road, with the same policies, the same practices. We're going to clear dine-in theaters within 3 miles. It was presented to Paramount. It was presented to Warner Brothers. It was presented to Disney. In the record is the example of the Paramount presentation. They've got this big, confidential Open Road just for you guys so we can communicate with Regal, and they've talked about it here. Go look at the record for the Paramount presentation. They're virtually identical. The same information is in there, and the testimony is that same information was provided to every single distributor. There was nothing unique about Open Road. Finally, the last thing I want to talk about here is there's this conversation over and over again that this information was passed along in 2012. And then Regal, supposedly in 2013, which it's true, in 2013 is when Regal made its decision with respect to iPic and told iPic, we're going to clear you in Houston, to which iPic's CEO, Hamid Hashimi, said, no biggie. Well, at that point in time, the theater in Frisco, nobody had even imagined a theater in Frisco. The uncontroverted evidence is that the developer in Frisco and iPic didn't even begin talking about iPic Frisco until December of 2013, 8 months later. It is literally temporally impossible for the two to have colluded on that. But now, going back to this idea that Regal changed its policy, let's assume for a moment that
Counsel,
Regal...
your time has expired.
All right. May I just finish this point with permission?
Briefly.
Okay. Assume Regal found out about the policy through Open Road or otherwise. If it decided that AMC's strategy to clear theaters within 3 miles, including dine-in theaters, was a good idea, it had the absolute right to consciously follow that decision, and the case law teaches that that type of conscious parallelism is no evidence of conspiracy whatsoever because it doesn't tend to exclude unilateral conduct. Thank you for allowing me the extra time to finish my comments.
Thank you, counsel. The case is submitted, and the court will take a brief recess.
All rise.